normal movement of judges around, right? Well, we looked up his background because in the law libraries they have judicial profiles, right? And we looked up his judicial profile, and there they tell about, how many kids he has and what school he went to and how long he was a lawyer and when he became a judge, all nice stuff. Well, included in his profile were two significant facts. One of them was he was a member of a private club of judges. This particular private club specialized in common law. They studied it on their own. They loved it. It was his thing. Okay? The second point that was significant is that this particular judge they brought in at one time was the head of the Appellate department. In other words, you had a municipal court case and something went wrong. You appealed it to the Superior Court Appellate Department. And the Appellate Department of the Superior Court is good enough so that they write case law. Okay? And he was the head of that. So what that told me is they brought in their top gun on this one. They got desperate. Did we win that contempt? I guess not. He never paid the dollar. But he was gone.
You've never been before the new judges.
Oh, yeah, we did it, and we're now going to write the judgment. We're going to write the judgment. Because it doesn't matter who he was, he can't make any decisions. Okay?
But he knew it. So
well, he was educated, right. He made it easier to work with him.
So he's not giving you any trouble.
I wouldn't say that. Doesn't mean they don't try. And they'll test your knowledge, sure. Okay, well anyway.
Well, if you're not tested, you don't learn anything.
Well, I suppose that's true too. Now, what was the question that I was going to look up something?
To describe the Nisi Prius court to the benefit of what the defraud and deceit is.
Yeah,
with how they don't understand our common law and vice versa. We don't
here we are.
The Nisi Prius.
Well, here it is, the Nisi Prius court. Okay? So, you know what a court of record is? Right? Okay, you've been through the 5 requirements of a court of record. Well, here's a Nisi Prius court. Okay? And basically, here's what a Nisi Prius court is. The mere keeping of a record does not qualify any court to be a court of record. Black's Law Dictionary, 5th edition, contributes to the confusion by listing only 2 of the 4 requirements for a court to qualify as a court of record. If you want the full explanation, go to that website. In California, all courts are named as courts of record. However, if in an individual case they are not operated as courts of record, then they don't qualify as such. It takes more than a name to make a court of record. Even though a court may be keeping a record, it is a court of no record if it does not conform to the remaining 3 requirements for a lawful court of record. Black's Law Dictionary omissions are subtle, but if you look deep enough, you can recombine the information and get to the real meaning of terms such as Nisi Prius. Nisi Prius is a Latin term. Individually, the words mean this. Prius means first. For example, prius vitias laberavinus, or nunc legibus, means we labored first with vices, now with laws. Quoted from Black's Law Dictionary. Nisi means unless. Quoting from Black's Law Dictionary, the word is often affixed as a kind of elliptical expression to the words rule, order, decree, judgment, or confirmation to indicate that the adjudication spoken of is one which is to stand as valid and operative unless the party affected by it shall appear and show cause against it, or take some other appropriate step to avoid it or procure its revocation. A rule of procedure in courts is that if a party fails to object to something, then it means he agrees to it. A Nisi procedure is a procedure to which a person has failed to object, or in other words, show cause. And therefore it follows that the person agrees to it. Or, conforming to the format in the preceding paragraph, a Nisi procedure is a procedure to which a party agrees unless he objects. So, basically, somebody says, hey, let's do something this way. No objection? We're doing it. Too late. Overruled.
You're in the lion's den.
Yeah, you already agreed because you objected after we decided to go ahead. But a Nisi Prius court is a court which will proceed unless a party objects. The agreement to proceed is obtained from the parties first. And so on. So the bottom line is that a Nisi Prius court is a court that proceeds unless somebody objects. The basis for objection would be, hey, you're not a court of record.
What if you object and they still go ahead?
Well, then they're wrong. Now you have a basis for appeal. Or if you're the plaintiff, you overrule them. You know, issue an order, which is what was done. You see, there was but in Aurora's case, the criminal court was not even a nisi prius court because an objection was made. So they weren't a court of record, and they weren't a nisi prius court. They were operating totally without jurisdiction, and they admitted it in their paperwork, in their demurrers.
If one was in such a position, would he object at an arraignment and establish his court?
Well, you don't wait till then. You object way ahead of time. But yeah, you would object. You say, look, because the purpose of arraignment is to secure your agreement. See, in an arraignment...
So you would object like in an arrest then?
Sure, anything.
Okay.
You always object. But, you know, you take, for example, in a normal court proceeding, you make the accusation, and then you have the judgment. That's your basic court proceeding. Now, if a person decides to answer your accusation, well, then that adds to the proceeding. But the minimum is that you make the accusation, he defaults, and so he gets convicted. He's presumed guilty until proven innocent. Okay? That's how it works in civil cases. But let's take, for example, let's see. You make the accusation in a criminal case. Well, the government is kind of special. We have a constitution to control it. So the government has to meet certain criteria. One of them is that it has to take the position that you're innocent, whereas normally the position of the plaintiff would be that you're guilty. But the government has to say you're innocent unless there's actual proof of guilt, beyond a reasonable doubt. Okay? So that's one condition that they have to meet. Another condition is that they have to prosecute you in a court of record, unless you agree otherwise. Okay? So what they do is you have this court procedure called an intermediate. And the other thing is they have to prosecute you when you're there. They cannot default you in a criminal proceeding. They've got to bring you in. Okay? So what they do is they arrest you, okay, bring you before a magistrate, and they say, you are accused of violating this code. Do you agree that the code applies and you're not guilty? Or do you agree the code applies and you are guilty? Or do you agree that the code applies and you plead no contest? In all three cases, do you agree to the jurisdiction? Now, they don't ask you that blatantly. They leave that part out. They say, are you guilty, not guilty, or no contest? That is a factual question. Guilty, not guilty. So, if you talk about the facts, you have agreed to the jurisdiction, because the jurisdictional issue has to be settled first. If you fail to object, you agree. So now you step out of the common law and you go into the statutory law when you put in a plea. That's why you don't put in a plea. That's why you object to the whole system. You force them to go to the common law. That means they can't use statutes. Yes.
At that point, what you do is you've relinquished the jurisdiction to the nisi prius court, and you have waived your rights to the common law, and they now have control over you.
Right.
Which,
by your failure to object, when you put in a plea, you're failing to object to the nisi prius court.
the fact of the matter is, in the California Constitution, it clearly states that all courts of the state of California, from the lowest juvenile court to the Supreme Court, is to be a court of record, of which consists of the common law. So why is there even such a thing in the court as a nisi prius court to begin with? That tells you that something doesn't pass the smell test.
Well, they're taking a shortcut. Yes, sir. Oh, I thought you raised your hand. Oh, okay. That's it.
Is an acquiescence to jurisdiction correctable by negative averment?
Well, there's always questions of fraud and being suckered into it, sure. You know, you raise those issues. You can, yeah. But then you can do the counterclaim, because, see, there's another rule that says that if a court does not have proper jurisdiction, it cannot acquire it, even if you agree to it. So, as Judge Bork said when he was nominated for Supreme Court Justice, he said that something like 80% of the people are in there voluntarily. Okay? Well, that's why. That's how they got, that's how they volunteered. You know, those guys, I don't know if he's part of the scam or whether he really is misinformed, but people do not know that they can opt out. You know, they don't have to be in that system. Did you want to eat dinner? Or take a break or something?
6 o'clock.
Yeah. 6 o'clock dinner? Now, last time it took an hour and at least an hour and a quarter.
6 hours.
You want to take an hour this time for dinner?
1 hour. Dinner is 45 seconds.
What is it? 1 hour? Okay. So we're going to go an hour.
Put the clock on.
Right. Okay. So we'll reconvene at 7.
Okay.
Synchronize your watches.
Way back at the beginning in the template, I forgot to write it all down. There was a reference to some.
Okay. Does anybody have any burning questions? No burning questions? Want to go home?
Well, I just
It has to be burning, get in the light, burning question.
Well, yeah.
You know, I just want to point out that, you've all heard of the 12b-6, failure to state a claim upon which relief can be granted.
Right.
Yeah.
I have made a little adjustment with that. The Bar Association has failed to state a claim upon which relief can be granted. And we now have a situation like in Aurora's case where these people will not recognize the common law, the court of record, or anything. And they claim immunity. And they demonstrate with vehemence their hatred for this woman standing for the common law and trying to restore some sanity to this country. And in that vehemence, Bill actually has on his computer there pictures of a woman who was viciously attacked, 73-year-old lady, process server, in one of Aurora's courts where we actually had 11 witnesses to the beating of this old lady, and she was tasered in the whole 9 yards. This is absolute insanity. And, I want to get a help wanted sign here, and I want you to understand that if we don't get rid of the Religious Bar Association, you can just about say that all the rest of this is going to be sucking, because it's a religious outfit, and that's all there is to it. And I don't care who wants to go along with it. Just remember, you've heard it the first time here in 2005, Rotten Huron wants to send the Bar Association to Mars. And when you see these pictures, you'll understand a portion of it, and how these bastards can claim immunity is beyond me. Anyway, go ahead, Bill. Show them the pictures.
Well, I got to find them first. I was talking.
Maybe now we know why people visit the local bar, right?
Huh? What?
5 weeks ago. Can you do it by time, hour, date?
Well, yeah, I can if I can figure out, but I think I got maybe have, here it is, right here.
6 weeks.
I think we got it right here.
Probably even longer.
This may be it. Yeah, this woman, well, I don't know if she's filed one against him or not, but,
Yeah, there's the taser marks.
oops.
Yeah, you can see the upper left there. That's where they tasered her a couple of times. We heard these horrendous screens out there. You know, they always have that little foyer. You know, when you walk into the courtroom, you got to go to the right or left of that little room. Well, as she was leaving the courtroom and the judge sicked these about a half a dozen sheriffs on her, they just lambasted her.
Yeah,
Tasered her. We heard these blood-curdling screams.
they slammed her against the wall.
She didn't even realize she'd been tasered. She went down later and got a police report, and they explained that's what those marks were, was taser marks. And she didn't know where all that horrific pain was coming from, but also being arthritic. You know. And let me tell you, that day when we went into that courtroom, there was 11 witnesses there for Aurora. The judge ordered us, the people there to witness for her case, out of the courtroom. Those of you that know Lex or Barbara Bush, whichever name you might know her by, she went down and had to complain to the sheriff's department to get us invited back into that courtroom. Well, when we got invited back in, with the sheriff standing there over the judge's neck, you don't think that didn't piss that guy off? Yeah. And so he probably knew that something was going to be coming down for the day, and he gave the goons, whoever I sick you on, make sure you whip them good. This happened to be a 73-year-old lady.
Yeah, that's a speculation, but, you know, you certainly saw the results.
Yeah.
Well, okay, our subject today had to do specifically with the format of a complaint, or actually an action at law, and the format of a motion. So we got a lot of other side stuff in there too. But is there any questions here you got about that, or
there's a lawyer in Oregon who spent 10 years and was disbarred up there for trying to get several other lawyers and judges to not pilfer a party's homestead after he died and all.
Yeah. You mean he demanded integrity?
Yeah.
Okay.
And he got so that they barred him from the court. Here's an ex-lawyer. They barred him from the court, and what he started doing was getting a group of 30 people to go in there, and the judge says, "Sick 'em," and everybody stood up, and the police backed off. This is how you got to handle it. You got to take a crowd in to control the police and the judge.
There was a group I heard about one time that they stood up when the judge had done something at some critical point. Everybody stood up at the same time. They all pointed at the judge at the same time, and they all said at the same time, "We accuse you of treason." And that seemed to kind of calm them down, shake them up, and there was a sheriff that mentioned to one of the people there that had you had so many more people, he would have had to take the judge into custody. And I think what it must have been, it basically amounted to a grand jury accusation if they'd had enough people. I know you need, in common law, you need 25 people for a grand jury. 25.
How about an Article 7 court?
Well, that may be statutory.
No, that's common law, Article 3 court.
An Article 3 court is statutory. Okay? Because it's specified by statute. A true common law court arises on its own by the sovereignty of the people. The government itself does not have common law.
Article 7 court then?
I don't know what Article 7 is.
Well, it's 23 good men.
Well, no, that's a statutory grand jury. You have to have 25. It doesn't work with 23.
Okay.
25 is specified in the Magna Carta.
Okay, 25.
Okay, yeah. Now, maybe the statute or the article says 23 somehow, but... Yeah. Okay, you had a question.
Yeah, let's say I as a plaintiff, I'm pursuing a claim or a counterclaim. It goes through the process. I, as the tribunal, issue my order. The magistrate records it. The other side wants to appeal it. when they go for appeal, does that make me the defendant in the appeal?
The defendant is whoever lost in the trial court level.
Okay.
You know, it could be either plaintiff or defendant.
So at any higher levels, past the trial court, or when I first made myself the one of the people on for the record and all that.
Well,
I'm not saying it right, but once I issue my order, do I? Is there any? Would there be any need to reestablish myself as common law court in any appeals or higher levels?
No. See, the thing is that the Court of Appeals and the Supreme Court have no jurisdiction because you had a court of record on the trial court level. They can't. There is no appeal. Okay. It's final. Okay. We got that in. Let me show you the case on that. Was it the Ron? Where was it that we did that? You remember? Remember we put those two cases in, and then we had. You remember that case about the finality of the judgment?
I believe that was in the contempt.
Okay, well, let's see. Was that in the... Let's try the bench... I think it was the bench warrant. Yeah, here it is. Yeah. Note 37. See if I can raise that up. I'll tell you what, I'll modify this. There, that raises it up. And then we'll go to... see if we can bring it within range. Okay. The judgment of a court of record whose jurisdiction is final is as conclusive on all the world as the judgment of this court would be, this court being the Supreme Court. It is as conclusive on this court as it is on other courts. It puts an end to inquiry concerning the fact by deciding it. So, once a court of record makes a decision, it's not reviewable. Because it's the sovereign himself, you know, right there.
Let me just add, Bill, that this is a comment from Chief Justice Marshall way back when. I'm not positive, but I think it might have been the first Chief Justice of this country. But this case was cited, if you'll notice the very last thing there, 1973. Somebody used it in their court case.
Right.
Demonstrating the power of the court of record.
Yeah. The court of record decision is final. Yes, sir.
Why does it say ex parte?
Ex parte means that there was no other party. That he was by himself. It was a decision without any other party. I don't know what the issue was, but the point is it was a court of record and the decision's final. And when somebody pushed it up the line, the Supreme Court said, hey, we can't touch it. The decision was final out of that court. It's beyond even our authority. And remember, the sovereignty is in the people. What does sovereignty mean? Not accountable to any higher power. Okay? So when the sovereignty of the government lies in the people, can the government now overturn the people? Not legally. Okay? That's the key thing.
There was one other thing, Bill, you found about 3 months prior to this one, and that was the one that explained the difference in the court of record being superiors and inferiors and so forth.
Right.
I don't remember whether that one was in this document or not.
It was Peter, so whoever Peter was, that was the name of the clerk. Peter. I think it's Peter.
On the new CD.
Yes.
Okay. I didn't get
well,
it copied down. So.
Well, I'm sorry. Okay, I think this is it here. Same thing. Let's see. The judicial power of this state is vested in the Supreme Court, Courts of Appeals, Superior Courts, and Municipal Courts, all of which are courts of record. Inferior courts are those whose jurisdiction is limited and special and whose proceedings are not according to the course of the common law. That automatically excludes the criminal courts because they're all going by statute. That's not common law. So now they are special courts. So it goes on to say in note 3, the only inherent difference ordinarily recognized between superior and inferior courts is that there's a presumption in favor of the validity of the judgments of the Superior Court and no presumption in favor of the validity of the Inferior Court, and that a Superior Court may be shown not to have had power to render a particular judgment by reference to its record. And it says, however, that in California, Superior Court is the name of a particular court. But when a court acts by virtue of a special statute conferring jurisdiction in a certain class of cases, Penal Code is an example, it is a court of inferior or limited jurisdiction for the time being, no matter what its ordinary status may be. Hey, to be a superior court, you got to act like a superior court. Just having the name doesn't cut it. Okay, that's what it's saying.
How about in our superior courts, courts of appeal, superior courts of appeal in California today? If you file an appeal in the superior court, they reverse the heading back to where it was in the lower case before the appeal, in the original case. Whereas when you're appealing, now you become the plaintiff. And when you file the appeal now in the superior court, they reverse that back to the people against so-and-so.
Well, I'm already lost in your description.
What are you saying?
Yeah, I didn't keep up with you.
You haven't found that?
I couldn't follow that. No, I screwed up.
One more time, slow.
You want me to do it again?
Take a chance. We might keep up with you the second time.
Let's say you got the state of California versus Bill Thornton.
Okay.
You go into their music precinct court,
Right.
and you lose.
Yeah, well, first of all, right there you're off the bat because you ran through their procedure. You've agreed to it, right?
Well,
I mean, right there.
no.
Okay.
This particular case I'm thinking of, it was not agreed to at all.
All right.
It was.
So you preserved your rights.
But nevertheless, in the appeal, you file it as an appeal, and they bring it in as like State of California versus Bill Thornton again. Whereas you filed it on appeal as Bill Thornton versus State of California.
Right, but you still show your original status. In other words, you're the appellant and defendant versus the appellee and plaintiff. I think that's how it shows on the court case. So even though you're the moving force, you were the defendant.
Yeah.
And so it would be, you versus them, but your original designation in the trial court level was defendant. So you're going to retain that for that appealed case.
The same jurisdiction.
Well, I mean, you're appealing a case.
You're the moving party now on the appeal.
Yes, you are the appellant, correctly identified as the appellant, but what were you in the lower case?
Defendant.
Well, then you retain that title underneath the appellant title. You have two titles. You're the appellant, you have your name, and then under that you say appellant and defendant, because the defendant applies to that lower case. It's just a double title, but they want to know, who's appealing? But the case, the relationships are identified. You're not going to call yourself the plaintiff when you were the defendant in that lower case, right?
Not in the lower case.
Well, in the lower case, in the upper case, you have new job titles. You're called appellant. You're not plaintiff. You're appellant. That term, defendant and appellant, defendant and plaintiff, those terms apply to the trial court, not the appellate court. When you go from the trial court up to the appellate court, they use different words so that there's no confusion. The word defendant and the word plaintiff apply only to trial courts. They don't use those words in the higher court on appeal. You have new titles, appellant and appellee, or respondent, appellant and respondent. That's just so, they want to know, when you look at a case, you want to know, well, okay, it's being appealed, that's good. We want to know who's doing the appealing and what was he in the prior case that's being appealed.